Good evening, and thank you for joining us today. I am Marcia Linsky. I'm a former magistrate, prosecutor, and currently a criminal defense attorney. I am hoping to use On the Level with Linsky to introduce new ideas and concepts involving the criminal justice system. I am hoping to provide information, and hopefully we can all learn something along the way. Tonight we'll be discussing one of my favorite topics and favorite areas of the legal practice, expungements, and hopefully if we have time, perhaps touching on sentence modifications. With me tonight is Monica Young. I have the pleasure of working with her at Close and Hitchcoch, the law firm that I am associated with. You can contact either one of us for any additional questions you may have about expungements, or almost any attorney in town that practices in the criminal arena. In regard to expungements, this is the opportunity that the legislature has created to essentially clear your criminal history. There are some offenses that don't qualify for expungement, but most do. There is a statute that dictates when and how you can get matters expunged. We have some questions that we found that clients often ask in regard to the expungements. One of them is, how long do I have to wait? Monica, can you give us some indication of the time periods for the waits?
Sure. So I think the short answer is it depends.
Yes.
So I have some notes here and you can correct me if I'm wrong, but for arrests, charges, or juvenile adjudications, it's a year from the date of that charge or arrest. For misdemeanors, the waiting period's 5 years from the conviction, so quite a bit longer. For level 6 felonies, so the lowest level felony, that would be a period of 8 years from the date of the conviction.
Okay. And the kind of difficult thing with the statute is there are some definitions that can pull you into the next level up under the expungement statute. At the time that this expungement statute came into effect, it was around 2013. That was the same time that there were a lot of amendments in our criminal statute going from class felonies to level felonies to kind of cover that gap between both the class and the levels. There are some definitions under the statute of just certain major felonies and what those definitions are. Some of the level 6 felonies, if there's an allegation of bodily injury, it can move you up to the next level of certain less serious felony convictions. So that's why it becomes important. A lot of people look at the statute and think this is a fairly simple process, but it's important to have an attorney to be certain that you're filing under the correct statute. Would you agree with that?
Yes.
Yeah. And the question, too, of how long do I have to wait, part of the statutory requirements are that you have to meet that time definition from the date of your latest conviction. So I've had clients contact me and say, I'm only interested in expunging this old felony that I have, but I picked up a misdemeanor a couple years ago. I can still expunge that old felony. No, that more recent conviction basically resets your time clock because the portion of the statute regarding what the court has to find says that time frame has to have elapsed since any convictions. So that can change some of your time frames and falls into that it depends what your wait period can be. Are there any felonies that don't qualify for expungement?
So if you're someone who, I think this answers your question. If you're someone who has to register as a violent or sex offender, that expungement isn't an option. I believe it's also homicide, voluntary manslaughter, involuntary manslaughter, felonies that result in someone dying, the death of a person. And there's also the official misconduct by a public servant, which wouldn't qualify either.
And are there any occasions where if I get permission of the prosecutor that I might be able to petition for expungement or even shorten some of these timeframes?
I would direct that back to you.
The statute does say certain level felonies, some of the higher class felonies, do require prosecutor consent in order to proceed with the expungement. The prosecutor also under the statute does have the ability to shorten the time frame. under the statute. However, I found, at least here in Allen County, most often the prosecutors don't do much varying outside of those statutory requirements. How many times am I eligible to obtain an expungement?
So you get one bite at the apple. People can go for an expungement one time in their lifetime, and that's why it's important to get an attorney to make sure that you have everything you need in that first filing, because once it's rejected, that's the end of it.
Now, if I have convictions in counties outside of Allen County, for instance, would I be able to file one petition in Allen County, or do I have to file in each of those counties?
So you'd have to file in each of the counties. One of the important things to keep in mind is that each of those filings in the different counties has to be done within a year of the first filing. So let's say you file to have things expunged in Allen County, but you have something you want expunged in Whitley County. If you're going to file for expungement in Allen County tomorrow, before April 26th of next year, you'd also have to have filed the expungement in Whitley County.
So it is important, if you're going to go to an attorney and talk to them about an expungement, you need to have all of your information about your criminal history background, not kind of parsing out and picking and choosing.
Right. You'd want to give them the full picture.
Okay, thank you. What about convictions outside of Indiana? Would I be able to expunge those here in Indiana?
Indiana doesn't have the ability to expunge or do anything with convictions that are coming from other states. So no.
And that's because this is just our state statute. It doesn't impact
Right.
other states. It also doesn't affect federal convictions.
No.
Okay. Does it go completely off your record? I mean, are the records destroyed? How does that process work?
So they're not destroyed. A good word is sealed. And basically what that means is they're no longer available for public access. The records of your convictions or charges can only be accessed for specific purposes or if a court orders that they be accessed.
And I found that to be very specific.
Limited, yeah.
Yeah, even if you're the attorney of record who filed the expungement, if you need to go back to one of the cases that was expunged and get some documents out of it, the clerk will require you to still get that court order to release those records, even though you were the attorney that helped get the expungement. So they follow that rule to the letter, that order from the court to the letter. Do you know when I file, when those records are sealed, does everything get removed from public records?
So, and this might be something I need a little help with, but I believe that for a background check and public records, if it's within, if it's public records, as in state records, things that public services are using, they can't access it. But sometimes there's third party background information checkers that might have that information.
That is correct, because some of that, and the other issue becomes that a lot of people don't think about sometimes when it comes to expungements, if for whatever reason there was some publicity about your particular case, that expungement order doesn't go to the newspapers. So if you were to do a Google search on somebody, even though they've had an expungement, that matter may still exist out there on newspaper records. The other thing that I think it's important for people to know, level 6s and misdemeanor convictions get removed from the court records, from the public eye. For felony convictions above a level 6 or class D, the statute says that the court record remains public record. It just simply has to be clearly marked as having been expunged. And I guess in my mind, that would be like a big stamp of expunged across the caption of the court record. Unfortunately, that's not the way the courts have interpreted that statute. And oftentimes what you find is there's just an entry down at the bottom of the chronological case summary that references this matter has been expunged. I often advise clients just be certain you keep a copy of that court order with you so that if that does come up, because so many people will go on to, my case has become so popular. It's the public access website that lets you look up court records for yourself and for anybody else you may want to look into. And if you pull that case up, even though it's been expunged, the CCSs, at least here in Allen County, tend to run oldest to newest at the bottom. So you have to read, I always refer to it as reading to the end of the book, and not everybody reads to the end of the book. So they miss that. So it's important sometimes if an employer, sometimes you do still have to address that with an employer, even though at the time this statute came into effect, it was during the time that there was a bit of a recession in the country, and this was viewed as a way to help people get back to work. So the employer's reaction to all of these is very important. Do you know, is there any need for a hearing at any point in time, or does this just happen automatically?
I believe it happens automatically. Correct me if I'm wrong.
For some of the lower level
Okay.
felonies, anything above level 6 or class D felony, there is a need for a hearing. Some of the counties will still have you appear, even though the statute says if you meet the statutory requirements that it shall be granted. For a lot of you out there, those of us that are lawyers know that word shall is a very important word in a statute because it takes discretion away. If it's may grant, the court has discretion. When it says shall grant, it just has to be granted if you meet the requirements. But prosecutors, almost without exception, aren't such great fans of the expungement statute. I presume you've run into that in filing some of the petitions. A lot of times they'll object just to object. My favorite language is here locally, finding no legal basis to object, which means we don't really agree with it, but we don't have a reason to object to it. But on the higher level felonies, anything above a 6 or class D, the statute does call for a hearing. And that can be an issue in dealing with some of the prosecutors because they want to go back to the facts of the case and what happened during the course of the actual case. And it's always been my position that the expungement statute wants to look at what you've done with your life since these convictions occurred, and that what the court should be considering in making the determination to grant or not grant is what you've done since that time. Have you found that to be true also?
Yeah, I would agree with that.
Yeah. Do you still have to bring these convictions up in a job interview?
So, no. You are able to legally withhold the charge or conviction after it's been expunged. You don't have to tell your future employer or potential employer.
And I think the language that's supposed to be asked on the application during the application process is, do you have any felony convictions that have not been expunged? Which allows you to answer that question truthfully if you've had them expunged. I think those were most of the questions. Was there anything else?
No, I think we covered it all.
Okay. So it can be a fairly simple process once you've met all the requirements. One of the other things that is very important too, that has just kind of crossed my mind, you have to have complied with all of the financial requirements of your sentence. So you have to be certain fines and costs have been taken care of. If there was ever a restitution order, that needs to be paid in full. So those sometimes, unfortunately, oftentimes, people who end up going to the Department of Corrections as a result of their sentence may forget that they've got fines and court costs outstanding, or even just court costs. So they come to get an expungement, and you have those financial obligations that have to be taken care of to meet the statutory requirements. That can add to a financial burden if you're looking to have these matters expunged. You get into kind of a difficult situation sometimes because bettering your employment can hinge on getting these things expunged. And if you have all these outstanding financial obligations, it can delay that process. There is also a filing fee unless you're proceeding under the statute, subsection 1, for a matter that did not result in a conviction. For those matters, there is no filing fee. It's been waived. It still has to be filed as an independent. These are all filed as independent new actions within the legal system. So if it's been dismissed, there is no filing fee. The other kind of unique aspect of the statute, if the once in a lifetime caveat applies to matters that have become convictions. If it's a matter that's been dismissed, as many times as you get arrested and have something dismissed, you can always petition to have those sealed. In fact, I think you can correct me. Last July, they started the automatic expungements for matters that have been dismissed.
Okay.
So you no longer have to petition the court for those. It will happen automatically. And that's, in my opinion, all very important, because if you've participated in a program like a pretrial diversion program through the prosecutor's office where you don't get a conviction, having that arrest record sealed is important, an important part of that. And most especially, as we talked about last time with the drug court program, that allows you to not have a conviction entered. It also opens up the door to have that arrest record sealed. So you have an additional benefit to the program of having that arrest record go away as well. And if that happens automatically, you don't have to worry about going back and taking care of that.
So we have a question from the audience.
Oh, wonderful.
As you were discussing the once in a lifetime, that seemed a little bit confusing to our viewers because, like you mentioned, what if that individual was out of state and they had already applied for their records to be expunged, and maybe they forgot, or maybe they were at an age where they thought it should have been expunged because they were under the age, and it was never done, and they don't include it in the application. So how does that work if it's only one time and you're done?
And that's why it's important to, if you're not certain, go to a law enforcement agency and see about having a criminal background run to ensure that you have everything. I know sometimes it can kind of be difficult. I'm fortunate because I've been around long enough. And I know some of the older processes when everything was on paper. So going back to some of those records, 1979, 1980 convictions, you really have to do some digging to find all the appropriate information. But it is very important. Unfortunately, the statute doesn't allow for any exceptions for simply having forgotten that you had this particular conviction. If you filed for expungement and it's been granted, if you're within that year that Monica talked about, you could still file a subsequent petition. Anything filed within that 365-day time period counts as one petition. Okay? If you forget past that year, you're out of luck.
Gotcha. Another question. With that expungement, if someone has expunged their file and they commit a crime or something happens, would that expunged record be used for a habitual offender?
Yes. There's actually an exception, a portion of the statute, that if you've had your criminal history expunged and you reoffend, number one, the records all still exist within law enforcement. They're just under a court order not to release that information. So, but the prosecutor under the statute has the option, if you reoffend, of petitioning the court to go back in and have all of those records unsealed. So that was an important concession when this legislation got passed. There was a lot of balancing between defense counsel and the desire of people. You have a person, I can remember before the expungement statute existed, somebody who's 60 years old who did something stupid when they were 19 or 20, stole from a store. They've got a theft conviction. They can't get that off their record because there was no mechanism to have that done. So giving people a mechanism to clear up mistakes is wonderful. If somebody's going to reoffend, yes, this can all come back.
Okay. Next question. You mentioned about at a job interview, you know, a lot of times people don't want to say that they've been convicted. Are you saying that the way the employers are to ask that question has changed? That way, the person applying for the job doesn't have to lie? Is that what you're saying? That the documentation for application for a job is going to change?
Yes, yeah.
Okay.
In fact, I've heard prosecutors refer to the expungement statute as the statute that has legalized lying on job applications, which is kind of a harsh way to look at it, but in reality, I guess that is kind of true because the wording is to be, have you been convicted of a felony that has not been expunged? So if they've been expunged, then you can legally answer that, yes, I don't have any convictions that have not been expunged.
And then can you again clearly state what convictions cannot be expunged?
Okay. Um, an elected official convicted of an offense while serving the official's term or as a candidate for public office, a person convicted of a felony that resulted in serious bodily injury to a person, a sex offense, most of the child molesting offenses, a person convicted of 2 or more offenses involving the use of a deadly weapon do not qualify for expungement under our current statute.
Thank you so much.
And I guess just briefly, we do have a few moments. Sentence modifications are another area that I tend to get a lot of questions on. I know, unfortunately, Monica hasn't dealt with that a lot, but part of my mission is to teach her about some of these things while we're working together in the firm. The most important thing when it comes to a sentence modification is you need to know if you had a plea agreement, what were the terms and conditions of your plea agreement? Plea agreements tend to act like contracts, and it is a contract between the court, defense counsel, defendant, and the prosecutor. So the only way to modify that contract is if all the parties agree to the modification. Most times, prosecutors, when they put together that plea agreement, they think it's an appropriate sentence, and it can be kind of a hard sell to get them to change the terms and conditions of that sentence. There's also the concept of modifying placement. That's the kind of situation where I've been ordered to serve my sentence at the Department of Corrections. I want to come home on home detention. There's also the residential services program that's considered to be kind of a higher level. They're both run by Allen County Community Corrections. Some of the differences on where you get placed is level of supervision and if you have housing that would qualify. So you also have to be within 3 actual years of the date of your earliest possible release date to qualify for community corrections. That's the greatest amount of time that they will take you into their program. And that's not them just being picky. There are actual evidentiary studies that have shown people's tolerance for the rules and strictures of a home detention program lasts for about 3 years. You go much beyond that, then you're going to end up with people violating because they just can't deal with it any longer. There's some case law that says modification of placement is also considered to be a sentence modification, and you still have to meet the requirements of that statute. Expungement sentence modifications are like everything else that we deal with in the criminal arena. There are specific statutes that address these particular areas, and you just have to meet the requirements of the statute. You have to be aware of the statutes that apply. The process for modification often depends on the kind of modification that you're asking for. One of the things that I've become involved a little bit more with of late is transitioning people from perhaps the residential facility into home detention. That's a process that takes less time because we can get reports from community corrections sooner. there isn't a need for a transport order or bringing somebody back from the Department of Corrections, so you can get that done a little more timely. On the other end of that spectrum are sentence modifications, oftentimes, especially in the drug cases, because they're the kind of charges that are not exempt from having sentences modified. So if you've gotten a plea that didn't call for a specific sentence, it called for a cap, you're going to get no more than 4 years executed. That left discretion with the judge. The judge has the discretion then to change that sentence. So that's going to take a little longer because the statute also says the judge can only consider that sentence modification if there's been a progress report filed from the Department of Corrections. So you have to request that progress report, which can take as much as 30 days. Then you file a petition for modification based on the progress report. Generally, the state's given 30 days to respond to that. So you're already 2 months in at that point. Then if the court can rule on that without a hearing. If the court grants a hearing on that, you have to request transport back from the Department of Corrections. Sometimes the court wants to see a screening report through Community Corrections to determine eligibility. So you may have to wait for that report to be filed before you can even set a court date. You have to set the court date out a little bit further to give sheriff adequate notice on the transport. So that can be a 4 to 6 month process, depending on how quickly reports come in and how everything flows at that point in time. Sentence modifications can be a little more difficult to get through. It depends. I know here in Allen County, we have some success with them, but there is an expectation among the courts that you should behave well while you're serving your sentence. And just because you're behaving well, you get time cuts at the Department of Corrections. That's enough of a benefit, enough of a reward for having done what is expected to do. It is nice when we can bring people home a little bit early, start acclimating them back into society, because that can be a major, major change depending on how long a person has served. And it does take a pretty big adjustment. So having that process kind of be slow-stepped with reduced supervision can be very beneficial for the individual returning. I know there's something, parole, a lot of the things put into the system are supposed to help with that. So doing above and beyond, that's going to be up to the individual judge. I can tell you too, from my experience, anytime somebody exercises their right to trial, goes to trial and is convicted by a jury of their peers, your odds of a sentence modification are almost none. The courts take the position that sentence modification is for those who accepted responsibility. So that puts things in a difficult position because everyone has that constitutional right to a trial by jury. And then having accepted that finding and going forward, should you not be treated like anyone else. But again, that's individual with the judge and the judge's philosophy towards rehabilitation and punishment. So I hope that we've been able to answer some of your questions about the process of expungement and sentence modification. I hope you've been able to learn a little something along the way this evening. As I said earlier, these are areas of the law that I have a great affection for because they do help people move beyond. People make mistakes. As people have said before, I'm not the only one to say it, the past shouldn't define who we are in the future. And so having that ability to clear some of these things off your background and not have that label on you as you go forward can be such a huge benefit. And that's why I enjoy helping people with this area of law in particular. So I want to thank you all for joining us this evening. I've enjoyed being here. I apologize for my voice. This wonderful Indiana spring weather has gotten to me along with so many other people. So thank you again and have a good evening.